Welcome back to Arise Prime Time. I'm Charles Ediagolu, and this wouldn't be prime time without the presence of our analyst to give his personal perspective on the news and issues we discussed here on the program. And today, I'm joined for the rest of the show by the lawyer, Arise Judiciary Editor, and Deputy Director of News, Tobi Soniyi. Thank you very much indeed for being here, Tobi.
Thank you.
First of all, so that we know what that we've been talking along the, you're the guy who keeps us all in line from a legal point of view and judicial point of view. Just to be clear on what we can say and cannot say, explain to us briefly what the concept of subjudice is.
Yeah, thank you, Charles. The concept of subjudice is that when a case is before a judge, we should allow the judge to decide the case one way or the other. We should not bring out facts that is likely to prejudice. So if the judge hearing that case is listening to us, his mind is likely to be prejudiced by what we say here. So that extends, and it's not for us to decide the case for the court. That exactly is what subjudice is all about.
But isn't there often a misunderstanding and a misinterpretation of that subjudice rule? Because I thought that the rule applies mainly in matters going before a jury. So just because a matter is in court doesn't mean that you can't speak about it, does it?
Well, we don't operate a jury system in Nigeria. We have a judge. We can probably what happened in court. We can talk about it, but what we should not do is deciding the case for the judge. It is exclusive to the judge to do that. Yeah, we can talk about it. You know, we report what was filed. We report what the judge says during the hearing, but we can't go beyond that.
But of course, a judge is not an ordinary person, is not an ordinary juror, for example. A judge is trained, so he or she can presumably insulate their mind and knows how to exculpate and exclude from his mind that which may influence him or her. A bit like you and I as trained journalists knowing how to remain objective. I mean, I can't go on air and say, you know, or be prejudiced in one direction or the other for a particular candidate or a particular party or whatever. We have to be down the middle, and it doesn't matter who I support or who I don't support. I have to be seen to be down the middle in a very objective way. I mean, isn't that expected of a judge?
Yeah, certainly, I got the point. But you should also remember that judges too are human beings. They can be influenced one way or the other. Yeah, they are not ghosts, they are not saints, they are not, they can be influenced. Yeah. So, I mean, because the authority is, I think it's a common law concept. You understand that?
Yes, it is.
Yeah, so they try to shield them.
Yeah, it is. But the origin of that law came from societies where they have juries in the UK, the US, that sort of thing. Absolutely. So I'm wondering why it actually applies the way that it does in Nigeria. But you have explained it fairly well. So thank you very much. Let's move on to the substantive issues on the program today. First of all, the case that we heard Oselo Kazikora, the public affairs and legal analyst, talking about, Emeka Nwajuba and another plaintiff asking the court to determine whether the APC is exempt from compliance with Section 90, subsection 3 of the Electoral Act, which states that any contribution to a political party beyond 50 million naira must be verified. And the candidates who purchased the nomination forms of the APC at a cost of 100 million naira, the argument of the plaintiffs is that those, the source of their money was not verified. Do they have a credible case?
Without
prejudicing.
But I don't quite buy the case, I must say.
Yeah.
I mean, in my view, I will ask the question. Is nomination form contribution to a political party? If you buy a form to do master in University of Lagos, for instance, are you contributing to, I mean, the university, or is the process? Because for me, I see nomination.
Well, obviously, if they're selling a form that they print for maybe 10 or 20 naira for 100 million naira, then clearly all the evidence suggests that they use that as a system, as a way of raising money for the party.
I'm not very sure of that. You know, if you want to organize a convention at Eagle Square, you're going to spend, it's a processing fee. That's where I see it. Maybe for a university,
well, that's 30,000
30,000 is enough to process a student fee. But suppose it's only one person that apply with that 100 million. Will it be too much for APC to organize, bring delegates from 35 states and all the rest of them? So me, I see it as a process. It's a processing fee. I don't see it. It's different from when parties say we want to raise money. Each person come and contribute.
Yeah.
Yeah, there is a. I mean, for this one, it's like trade and buying thing consideration. You pay the fee, they give you the form. If you don't pay, you don't get the form. So, well, it's for the judge to determine whether it is or not. Then the other issues, okay. I mean, like I always say, the qualification for Nigerian president is one of the simplest in the world. So that you must be 40, a citizen of Nigeria, must be sponsored by a political party, belong to that political party, and that the fourth one, that you have a living school certificate. So that is the requirement to be president. And even there is one that say, if INEC is satisfied, any other qualification you give, as long as INEC is satisfied with it, you are qualified.
Right.
It's even subject to the discretion of INEC. So that if you are, for instance, Tinubu has been governor of Lagos twice, so he's qualified. President Buhari said his document were with the military. He was qualified. So I don't see any issue.
So there's enough precedent there.
Absolutely. But I got their point that he claimed earlier that this and that, well, that is also for the court to decide. But what I'm saying is that to be president, this is the requirement. The question is, does he meet those qualifications or not? And the answer
and INEC determines that.
Absolutely.
And INEC clearly determined that in the past, which allowed him to have 2 terms as a governor.
Absolutely.
Right. So let's turn to the other issue from the Situation Room, where they were talking about the fact that there's so much litigation at the moment. There are concerns that court orders that seem to be making new rules beyond the Electoral Act with regard to the conduct of primaries. What is your take on that?
Yeah, I got their point. I understand the point they are trying to make, but I don't quite buy it. For instance, they are citing Section 29(1), but Section 84(14) say that anybody who is dissatisfied with the process of this primary can go to court.
Yeah.
So what do they expect the court to do?
Absolutely.
To just take the case and sit down? Is the judge not going to make all that? And besides, the Electoral Act cannot circumscribe the power of the court. If you look at Section 6 of the Constitution,
that's a very important point.
The court had very wide powers. And besides, for me, the way to look at it is that under the Electoral Act, each party has its own obligation. Political parties have their obligation. And one of them is that they must nominate candidates before 180 days to the election, which they have done.
Yeah.
They fulfill their own. So if the court has its own obligation. If a court come and say, look, that thing was not validly done, it's for the court to determine how to redo it. That you cannot begin to blame the political party for it. INEC also has its own obligation. INEC believed that they monitored the conduct of the primary and they were satisfied because INEC has the power under section, I think, 84(13) to reject any candidate from a party that had failed to comply with the provision of it. So if INEC monitored the primary and they conclude that they fulfill the conditions, so the party is in order, INEC is in order. But if one party, an individual, as in section 84(14), so you can go to court to challenge.
Yeah, but obviously they've gone to court, and the court has asked them for the primaries to be conducted again.
Yeah. So, but I think Situation Room is looking at a situation where whichever party whose primary was declared invalid should not be allowed. The candidate should not be allowed to participate in the election. That is what. That's to me. seems to be the point they are making. But then, we are in a democracy. If somebody, we are competing.
Yes,
we are running and somebody's leg is tied and another is allowed to run with two legs while the other... Well,
absolutely, it wouldn't be fair.
Yeah.
And I suppose the other issue that they raise is the fact that, I mean, that he raised here, Mr. Ugochukwu, is that if the fact that these cases have been left this late before decisions are made, he was suggesting that it was almost like a betrayal of the Electoral Act because of that timeline in that act.
Yeah, I got that point. There are, even within the law, there are provisions within which pre-election matter must be concluded.
Right.
As long as the court are still within that provision. But our courts are already very overwhelmed. They are already too busy. There are criminal cases suffering there. Other land issues are suffering there.
So you've got to wait your turn, basically.
As far as I'm concerned, the politicians are having a good time. Their cases get determined very fast. But there are people facing robbery, facing that are likely to be condemned to death. Their case spent 12 years. But politicians file today. Before you know it, next week they get judgment. And if they are still not satisfied with that, I don't see how more the judiciary can help them, because the court is already suffering because of overload because of cases. But the point must be made that politicians must learn to abide by the rule. It's because they fail to abide by the rule. That is why people keep on. If the rules are fairly clear, and you know that if you go to court, you don't stand a chance,
then there wouldn't be any basis for that.
Discourage some of this litigation.
Yeah. That's a very good point. I want to thank you very much indeed, Tobi Soniyi, for your legal insights there. And of course, Tobi is a lawyer, Arise Judiciary Editor and Deputy Director of News. Thank you very much indeed.